Hello everyone, welcome to John Redmond, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmond.
And hello everyone, I'm Shauna Sanford. Welcome to the show. Well, if you ever find yourself in a situation where you need an attorney who will zealously fight for your rights, you want to make certain it's someone who you can trust. In order to protect your rights, attorneys are held to high ethical standards. Now, on the other hand, attorneys need to be able to trust their clients. Both sides have certain duties and responsibilities to each other. Well, today, we're going to help you get clear on just what is expected from each side. Clients, lawyers, ethics, advocacy, and results. CLEAR for short. That's the focus of today's show and next week as well.
Should a client tell his or her attorney everything, even if it's something the client doesn't think is important or finds embarrassing? What can happen if a client doesn't tell the whole truth? Our guest certainly knows a lot about the attorney-client relationship. Frank Buck Jr. is a veteran attorney with nearly 30 years trial experience. He's handled offshore and personal injury cases. Currently, he's focusing on environmental law.
He certainly knows a lot about the attorney-client relationship, and we're looking forward to talking with him. But you are an attorney, have been for a long time. You've heard the jokes about attorneys and ethics. And what is it that you really want the public to understand about ethics when it comes to practicing law?
Well, it's going to be a good discussion. Frank Buck and I, he and I do a lot of the same thing. In representing clients, one of the most important things, and the same holds true, by the way, for attorneys who represent defendants in cases. Either you're defending a corporation, insurance company, a bank, a mom and pop outfit. You have to have trust. And the short answer is clients need to tell their attorneys everything. Let your attorney decide that what under the law you are obligated to tell the other side in litigation. You have to have that trust. So ethics obviously plays a very big role. You have ethical duties and responsibilities. Cross that line, the client can get in a lot of trouble, the attorney can get in a lot of trouble, and let me tell you, attorney's reputation, that means everything. The jokes aside, your reputation tells the judge and the other side whether or not you are to be believed. So it's going to be a good discussion. Look forward to it.
It is. I'm looking forward to it as well. Well, when we return, attorney Frank Buck Jr. talks about ethics and making sure that when an attorney and client join forces, they are really on the same team. Stay with us. We'll be right back. Hello everyone, welcome back to the show. Clients, lawyers, ethics, advocacy, and results. That creates the acronym CLEAR, which is the focus of our show today. We're going to try to bring into focus some of the important things you need to know about the responsibilities lawyers and clients have to each other when it comes to presenting an effective case.
We're happy to welcome attorney Frank Buck Jr. to the show. After practicing law for nearly 3 decades, he knows quite a lot about the topic, and it's such an important one that we're going to spend time on it today and next week as well. Frank, old friend, I'm glad to see you here. Instead of the courtroom, we can relax, we can talk a little bit about this important topic. And after all the time you've spent fighting for your clients, battling in the courtroom, we welcome you and your expertise to talk about with us this very important topic, that is ethically representing your clients. Today's focus, lawyer and client relationship. So thanks very much for being here.
John, thank you, Shauna. It's a privilege to be here to talk about such an important topic.
It is great to have you here. Well, both of you have been practicing law for quite some time, and I just got to know, over the years, does anything surprise you at this point when it comes to dealing with clients?
Not as much, but still, yes. Yes, there are.
Some things surprise you.
Yeah, based on how much time you spend discussing what we're going to talk about today, and they still do a 180.
They will.
And so that's why I thought this would be a great topic to talk about. The more we inform the public about how that core is so important to the ideal attorney-client relationship.
Yeah, and John, what about for you?
Well, not a lot surprises me, but for the most part, the vast majority of the clients, and I think I could speak for both of us, our clients are good people. They don't ask to get hurt. I mean, Frank mostly represents injured individuals. I do too. Our clients don't ask to get into accidents. They don't ask to have dealings with lawyers. They don't ask to have dealings with insurance companies. Sometimes their expectations, what do they know about the law? They watch TV. They see what happens on TV. Sometimes their expectations are really humble and it's touching. Sometimes their expectations are unrealistic. You know, they think they really should get paid more than is realistic in our imperfect legal system. But it's very rare that I think somebody is the commercials that say that people are trying to game the system. I think that's a PR rule, and I have my bias, and that's my full disclosure. I am a personal injury attorney. We don't talk about personal injury on the show, but that's my bias. How about you?
I find that many people almost are reluctant, they're embarrassed, they have to come see a lawyer, and they're almost apologetic. And it's like, well, this is what you're stuck with, just as you said, John. You didn't ask for this to be imposed upon you, and so let's start working together, and today's day one.
So when you come together, when you meet someone, I mean, it's fair to say that that client is evaluating you, and you are evaluating that client. So what is that initial conversation like?
Lengthy, because you don't want the client to leave your office with anxieties, and they want to feel comfortable. So you're beginning on that core of exchanging information and trust. They need to know when they leave your office, I picked the right guy. And that's through the development of the conversation that you have with them about what it is that you can do for them, depending on the nature of their need for legal services. And then from that point forward, they feel comfortable that they have come to somebody who's willing to spend the time with them and answer their questions.
How do you rein in those expectations?
Often and early. Often and early. And that is from day one when you, whether it's business litigation or whether it's a personal injury case, you try to tell them how cases are evaluated, and there are ranges. And so you have no idea when a person has an injury in an automobile accident, what's the value of the case. So you begin to tell them what the yardstick looks like to evaluate cases.
Yeah, and let me broaden, if you don't mind, Sean, let's broaden the discussion, because what we try and do on this show is, you know, we want to present it in a way, and Frank, before your long career representing injured people, you spent some time as an insurance defense lawyer, which certainly helps you in your career helping the injured. But I want to broaden it even further and say people who have the scary position of being charged with crimes, they seek out criminal defense attorneys. And we've had criminal defense attorneys on this show talking about what's involved there. Whoever your attorney is, maybe you are a leader of a corporation, maybe you have a small business and you have to get an attorney to help you in a legal situation. Whoever that attorney is, it boils down to trust. It's a good idea too. It's not a good idea. I'd say it's a requisite. You must check out the credentials of whoever's going to be your attorney, whether it's a corporate matter, a criminal matter, personal injury matter. Make sure, and then you go sit and you talk to that attorney. Typically for personal injury matters, never in a personal injury matter do you have to charge to go talk to the lawyer. Corporate matter, you might have to pay something for a consultation. Criminal matters, you might have to pay for a consultation. But call first. That's what the internet's for. That's what the telephone is for. Spend that time. Make sure this lawyer doesn't simply talk a good talk. Does he have trial experience? Does she have trial experience? Don't take their word for it. Check them out. Go to martindale.com. Go online. See what other client reviews are. Hopefully, if this lawyer's been out there for a while, he or she's got a track record. Do that. What do you say, Frank?
Oh, absolutely. First of all, in today's media, the ability with the internet and Facebook and Twitter, etc., we shouldn't have to throw a dart in the dark, so to speak, and guess on what kind of lawyer. Most of us know somebody at some point, either a domestic case, criminal case, has hired an attorney before, and we can get referrals. And so if somebody recommends an attorney, that's the first step towards an ideal attorney-client relationship, is that they've come favorably recommended.
And a referral is maybe one attorney referring you to another attorney, maybe a domestic attorney, a family law attorney who says, I don't do personal injury, but I'll recommend Frank Buck or John Redmond or Joe Blow or Susie Q down the street, right?
Oh, that is a great way. And if somebody has trust in a lawyer in one area of expertise, is to ask that lawyer rather than throw the dart in the dark. Another way is somebody through their neighborhood, church organizations, etc. They go, I'm going to need to talk to an attorney. This is looking more than I thought it was going to be, and I need to go talk to a lawyer. So what we call word of mouth.
Word of mouth, very important. And so once you decide to take a client on, what is the conversation like when you say, okay, here is what I'm going to need from you? Then what follows?
Well, what I try to do is make it clear that we're going to be on a two-way street. I'm going to try to explain to you as often as I can what to expect and how the process is going to work, but I need you to give me full disclosure. So we got to develop this comfort zone of disclosure, no misrepresentations. An ideal client-attorney relationship is one built upon trust. You know, down in South Louisiana, we all eat and make a lot of gumbo. You can't have a gumbo without a roux. It might be a soup or a stew. But trust is the root to the attorney-client relationship, and you want to reach out in that first meeting. Some of my meetings with clients on the first visit last sometimes 2 hours.
Okay, very important.
Yeah, we're going to start building this road. The first foundation is that trust.
And let me add to that and say it in a slightly different way. That root, that foundation of the meeting, that's really, we're getting to the ethics, okay? Ethics is the trust. Trust is the foundation. In a very similar way, any attorney worth his or her salt is forming that trust foundation. I have to tell you, if you can't trust your lawyer, and if your lawyer can't trust you to have wide open, two-way communication with the good, the bad, and the ugly, then both of you need to look elsewhere for. Client needs to look elsewhere for an attorney. Attorney needs to look for a new client. And likewise, I explained to the client, look, you came to see me because you've got a real issue here. If it's an injury case, an insurance case, you tell me the good, the bad, and the ugly. Under attorney-client privilege, I'm not going to go talk about it with my friends and colleagues. That is sacred. Now, eventually, if there's a case, some of that information, you trust me to know what I have to tell the other side. But you trust your lawyer to carefully safeguard that information. But you also tell the lawyer the good, the bad, and the ugly, because the lawyer can do damage control. That includes prior accidents and injuries, prior lawsuits, criminal convictions. But you share it all with the lawyer. You share it all with the lawyer. That's important.
That's your foundation. I agree, John. That's 1,000% correct. And if you go to an attorney for the first time, and it was a word-of-mouth referral, and it's business litigation, you have a small company, and the big company's trying to take advantage of you, and the lawyer says, look, I need to know everything, and all of a sudden he's asking about personal domestic stuff. That has nothing to do with it. Now it's time, maybe you pull the throttle back and let your fingers do the walking and get another referral.
That's a good point.
But during the initial interview process, like two dogs in the junkyard, you're kind of sniffing each other out. And so how the attorney asks about things, and the client goes, what does that have to do with it? Well, you better be able to answer that and explain to them and give them an example how courts may have.
Ask the lawyer the question. Tell me, why do you need to know that? And a good lawyer is going to say, I'm glad you asked that question.
Right.
Let me explain why.
Well, because if you have any uneasiness whatsoever, you shouldn't leave that office having any uneasiness about the encounter that you've just had with that attorney. And John, you mentioned something that I hope we'll get a chance to expound upon. We have to take a quick break, but the attorney-client privilege, what does that really include, and are there any exceptions? We'll get to that, plus our great viewer questions when we come back. We are going to take your questions for our guests, so stay with us. We'll be right back. Hello everyone, welcome back to the show. Our guest today is attorney Frank Buck Jr. and we're talking about how attorneys and clients can ensure that everyone is operating ethically and above board when it comes to presenting an effective case. Now you all have lots of questions about this and we're going to get straight to it. We were just talking about the attorney-client privilege going into that break, and our first question from Jason I think really goes right along with that. He says, I got hurt about 10 years ago, but I got better. Why should I have to tell my lawyer about it if my recent accident has nothing to do with it? And you said not very long ago, full disclosure is what you're expecting from a client.
And I would say if Jason was sitting right here, Jason, what is relevant and what's not relevant will not be agreed upon by, you put 10 lawyers in a room, 5 out of 10 would say it is and 5 would say not. We have code of evidence for that, and you need to trust your lawyer that if you tell him everything up front, he knows when and how to do, as John used the term, damage control. But he can't do damage control if you decided to withhold that information, the other side knows about it, and then they use it against you because you withheld it.
And your attorney's completely caught off guard.
Totally.
Has no idea what's going on. Talk a little bit about the attorney-client privilege. That's something that you mentioned. When does that begin? Are there any exceptions to that? What does that really mean, John?
Well, attorney-client privilege basically says whatever you share with your attorney is presumed by law to be privileged, which means if you tell your attorney, maybe it's a deep, dark secret, you cheated on your income tax, you did something really naughty, something illegal. By law, the attorney is not allowed to report you to the IRS, go to the police. Now, there are some exceptions. If you say, I'm going to go blow up a building, you say something that puts other people's life, limb in danger, then the attorney is going to be obligated to prevent further harm, even property from being put at risk. But the important thing is, by and large, when you tell the attorney about other injuries you've had, other accidents you've had, that may well be relevant because unless you're a medical doctor, unless you're a lawyer, and even if you are, you don't get to decide if that evidence can be explored further by the other side. Because if, let's say, if it's an injury case, if you had an injury 10 years earlier, even if it got better, the other side can explore that to see if maybe you're not having a flare-up that explains some of the symptoms that now you're complaining of from this new accident. And so talk to your lawyer about it. Explain it to your lawyer, let your lawyer explain it to you, and trust your lawyer not to go shouting it from the rooftops. And maybe your lawyer can file a motion why you don't have to give it to the other side, or fight the motion from the other side.
So does this confidentiality start from the moment I come and sit down with you, even before I agree to sign on with you as my attorney? Does it start at that moment?
Absolutely, Sean.
Yeah.
At that point, the lawyer, what I like to do if somebody's, I would say we're at a wedding reception or birthday party, I say, you got a penny or a nickel, and they give it to me. I said, okay, now you've given me something of value. Before you even ask me a question, the attorney-client privilege is now invoked. And I have to keep any information that I can't use in furtherance of whatever interest you need from me confidential.
Yeah, but one little exception I like to point out to my clients. If you say, hey, Attorney Redmond, the sky is blue. Well, you've told me something I already knew. So I can't suddenly tell other people the sky is blue, or that, if you tell me something that's already in the public domain, it's already public information. You didn't tell me. Now, if you tell me that that Little Willie, the third horse in the 5th race, is going to win the race, and nobody else knows this, and I deem it credible because you're the horse trainer of all the horses, well, okay, that would be an example of something maybe privileged. But in general, you can't make something privileged that isn't that's already public knowledge.
Okay, all right. Our next question comes from Barry, who says, when I got treatment after a recent slip and fall, I had to fill out a bunch of forms about past injuries and treatment. I'm not sure I wrote everything down, and what does it matter if those old injuries all got better anyway?
Excellent question.
And I'm sure there have been lots of times where clients have just forgotten, that something happened.
Excellent. And what I try to emphasize is everything you say can and will be used against you. And in injury cases, what you don't say, you should have said, will get used even worse.
Okay.
So it's easy to say, you're filling out forms. I've had some injuries and I had some treatment, but that's been years ago and I got better. We don't expect people to have 100% recall every day of their life. So if it's been 20 years and you had a little bursitis in your elbow and now you got a low back pain, obviously there's no relevance to the bursitis, but if you didn't put it in the record, they can and will use that against you.
Okay.
Yeah, and let me explain further. What happens is, not all insurance companies, but unfortunately lots of them, they will it's almost like one of those Monopoly, one of those board games. They'll take the rules, these clever insurance lawyers, and again, you got clever plaintiff lawyers. I'm not trying to paint everybody as good on one side and everybody bad on the other. They'll say, well, we found out by digging around that you had an injury before. And when the doctor asked you about all your injuries, you didn't tell him about that bursitis on your elbow 20 years ago. Aha, we caught you. You were trying to keep something secret. Now, maybe it's got nothing to do with your injury now, but you didn't know that. Maybe you were up to no good, and they want to try. It's like character assassination. It's mudslinging. So your intentions may have been innocent. People forget that time they went to the emergency room and you hung around for 2 hours and you went home. But it's really at times a sneaky game. So we try and remind people, look, tell the doctor about all your medical treatments. Hopefully it's going to be something the doctor can use to make you get better today, even though it happened a long time ago. But it can be used, and it will be used against you if you innocently forget to put it on there.
Example I comes to mind years ago. A client had gone to the doctor and was complaining of low back pain. Turns out it was a kidney infection. And it was not a back injury, it wasn't a fall, it wasn't an accident, it was kidneys. Fast forward 15, 20 years later, client has on-the-job injury and has a back accident. This is back pain. So then client forgets about the kidney and says, oh, I never had prior back pain. And as John was eloquently describing it, the gotcha syndrome kicks in. We got you. You didn't tell your back doctor about this back pain. Well, doctor, it really wasn't back pain, it was kidneys. So those are the things. So what's the moral of the story? Tell your lawyer everything. Let them, because the rules of relevance, it's going to be what the judge says during trial. And everybody has a different relevance filter. Trust your lawyer, give him everything.
Yeah. So if you have this feeling, I don't know if I should, give it to him anyway, or give it to him.
When in doubt, disclose.
Disclose.
And know that the lawyer's not going to be, the lawyer wouldn't care to, but the lawyer's not going to go share that with other people. Anyway, only what the law requires that the lawyer share.
Okay, well, brace yourselves, because we've got an interesting one from Faith. She says, most lawyers are mean and greedy. If I picked up the phone to call one, they would charge me by the minute. How should I go about finding a lawyer who I can trust? Who wants to talk to Faith first?
Faith, be glad to tell you. You talk to people that you know. In today's society, somebody has had some type of document transaction. They had to use a lawyer. They've been in a previous accident themselves. Get word of mouth referral. Start there. And as John mentioned earlier, if it's an injury case, it's free consultation. Costs you nothing to pick up the phone. All lawyers being mean and greedy, I understand that. But it's going back to the gumbo. If you put all these wonderful ingredients in the pot and the roux burns, the whole gumbo's bad. Well, in the legal profession, you can have one or two bad lawyers, but we don't have to throw the rest of us out. And I disagree with that. I am friends with a lot of my colleagues, very reputable, high integrity, and Faith obviously has had a bad experience with one lawyer.
Well, and let me tell you, that in the news media, in the television shows, a lot of lawyers are presented as sneaky bad characters, and that's unfortunate. Most lawyers are out there supporting their families. The ethics rules are very strict. If you misbehave as a lawyer, you will get in big trouble. Your license is on the line. Your reputation is everything. Your reputation means judges know you, insurance lawyers know you, and if you're on the other side, same holds true. If you're an insurance lawyer and you are a dishonest person, everybody knows it. So I think that's a myth. It's a misconception. If you're bad, you will get in big trouble. The Bar Association number is 566-1600. Report them. Report them. Go online, see what other clients review you. Nowadays, in Facebook and everything, you're a bad lawyer, people will report you. But you can find out and find a good lawyer. Interview them, you don't like them, fire them. Halfway through the case, you don't like the lawyer, fire them. It's okay, it won't cost you extra fees.
Well, that's a very interesting point that you just brought up. How much access should a client have to an attorney? I mean, you will have lots of cases. And so how often should I be in communication with you, you be in communication with me? You know, there are certain situations where clients get upset because they can't get in touch with the attorney when the client wants to.
That's the #1 complaint. If I meet with you on today's Tuesday, if I meet with you on Tuesday and we spend an hour and a half and I explain where we're at in the case, what you can expect and where we're going, I think it's unreasonable for you on Thursday to go, how's my case going? But if you haven't heard from the attorney in 2 months and there was supposed to be a triggering event in the interim, yes, by all means, track that attorney down. You're owed what I'd call a activity status report.
John?
I absolutely agree. Most lawyers today, they don't do such a good job. Well, I take that back. Most lawyers do a good job. However, if you're one of those people out there and you say, my lawyer won't call me back, I don't know what's going on with my case, I always say this when I get a call from somebody. I say, do your lawyer one favor. Get him one get out of jail free card. Say, if you don't let me know what's going on with my case, give me something in writing, I'm going to go get a new lawyer. I'm giving you this one opportunity. Put it in writing so it's not a he said, she said later on. Then, if that lawyer doesn't straighten up and fly right, they don't deserve you, and you don't deserve that lawyer. That's what I say. Make your client happy. That's how lawyers are successful. Don't make your client happy, well, then you don't deserve that lawyer.
Well put, John.
We have come to the end of this show, but we have so much to get to. And Frank, you're going to stick around. We're going to do another show, right?
I hope so.
Okay, great. Thank you so much. Appreciate your time.
Thank you for having me.
Excellent, thank you.
And thank you so much for joining us today. Be sure to join us next week when we'll continue our conversation with attorney Frank Buck. We'll cover more on what the attorney-client privilege really means and what duties and obligations both sides have to each other and to the court.
Start sending your questions through Facebook, email, and Twitter. Also, visit our website at johnredmondpoa.com for more information. Thanks for watching, and we will see you next time.